Hello, my name is Cindy Waterson. I'm a contract attorney for the Frank D. Lanterman Regional Center. And we're here today to talk about conservatorships. We have a series of videos that we are producing to help you through the transition period of as your child is beginning to turn 18 and what to do during that period. This video will deal with conservatorships. So there are different types of conservatorships. But going back, as your child is turning 18, you need to be aware that an individual is presumed to have legal capacity by law. So as your child turns 18, the rights and privileges and responsibilities that you had as a parent are no longer legally applicable. So your child is presumed to have the legal capacity to make his own medical decisions, to decide where they're going to live, to make their decisions regarding education. So that magical day when they turn 18, that right is now theirs and is no longer yours. So you may be lucky and your doctors and the school and the regional center may continue to talk to you for a while, but it won't be long before they are asking you for your conservatorship papers or that your child make those decisions. So we need to look at whether or not your child has the capacity to make those decisions. So if a loved one lacks capacity, so if your child does not have the capacity to decide medical decisions, medications, IEP decisions, IPP decisions with the regional center, then a person will need to be appointed as a conservator to make those decisions for them. I'm going to go back just a little bit before we go on to the different types of conservatorship. In one of the other modules, we talk about what to think about before you get to the conservatorship. So in case you're watching this module by itself, I wanted to go through that real quickly. As your child's turning 18, it's important to work with your circle of support. So the regional center, your school, your family, and really talk about, and with your child, of course, and really talk about whether or not your child has these abilities. Now, he may be able to make some decisions, but not all. There is something called a power of attorney. If your child has the ability to understand that he can appoint you as an agent so that you can help him make decisions, he may be able to sign a power of attorney. And in that case, if you have a power of attorney, so you are the agent under the power of attorney and can help him make decisions, then a conservatorship would not be necessary. Because in a conservatorship, your child loses rights. And so, of course, we always want your child, and especially as a parent, you want your child to retain as many rights and to be able to grow and be as self-sufficient as possible. So if a conservatorship is not necessary, then you would look at a power of attorney. So in this module, we have passed that. So we've come to the decision that your child can't understand the ramifications and the consequences of signing a power of attorney. And the circle of support has really decided that a conservatorship is necessary. So what do we do then? In California, we have different types of conservatorship. There's actually 3 different types. The first one we'll talk about is called an LPS conservatorship. LPS are the initials for Lanterman Petris-Short, which are the legislators that wrote the bill for this law. This type of conservatorship is defined by an individual who is found to be gravely disabled and unable to care for his food, clothing, and shelter because of a mental illness. So this is not a developmental disability. This is not dementia, Alzheimer's, something like that. This is because of a mental illness. In other words, schizophrenia, bipolar disorder. An LPS is appointed through the mental health court, and that court is in West Hollywood right now. I'm sorry, North Hollywood right now. And it must be renewed annually. So every year, this conservatee and the conservator must go to court and renew this. And this is the only conservatorship where the conservator is given the authority to consent to psychotropic medications and a consent to placing the individual in a locked psychiatric facility. No other tool, no other conservatorship will allow you that authority. So as a parent, you cannot admit your adult child into a psychiatric facility without this type of an LPS conservatorship. Most of us are not involved in this. This is a different type of diagnosis than most of our kids have, but I wanted you to be aware of this. The second type of conservatorship is called a general conservatorship, and it's through the probate court. All probate hearings in Los Angeles County are heard at the Stanley Moss Conservatorship on Hill Street downtown. A general conservatorship is a conservatorship granted for a person who may have dementia, perhaps brain injury. Typically, it's someone who had full capacity at one point in their life, but has since lost that. You can obtain a conservatorship of the person, which means making decisions for health care, where they're going to live, this sort of thing, or a conservatorship of the estate, where you have authority to manage their finances. Again, this conservatorship is through the probate court. It is good for the life of the conservatee. So as long as the conservatee is alive, the conservatorship continues. If the conservator passes away or is no longer able to act on behalf of the conservatee, then someone else can be appointed to fill that vacancy. You don't need to reapply for this. Again, it's good for the life of the conservatee. The third type of a conservatorship is called a limited conservatorship, and that's really what we'll be talking about for the rest of this module. In California, the legislature drew out this type of a conservatorship from general, and it's specifically for people who are eligible for regional center services. So if someone has an intellectual disability or a developmental disability, then they would be eligible to receive the limited conservatorship. Again, this is through the probate court, and it applies only to individuals who are eligible for regional center services. This is effective until the death of the conservatee or the conservator or further order of the court. And the reason that that's different is the legislators believe that the relationship between a conservatee and a conservator is so intimate that you can't just put someone else in that place. For limited conservatorships, as parents, you know this, you know things that other people don't. You know your child so well, you know what services and supports are necessary to keep your child on track. You can't just replace a conservator, a limited conservator, with someone else who wouldn't know your child as well. So if the conservator passes away or becomes ill and can't serve any longer, then this conservatorship actually terminates. So we often recommend that there's more than one person. If there are two parents, then both of them can act, and perhaps even adding an adult child. The conservator in a limited conservatorship is given authority to manage only the areas of the conservatee's life that the conservatee cannot manage by himself or herself. So these areas are broken down in the Probate Code section 2351.5 into 7 different areas. And you need, when you file your petition to the court, you need to explain to the court why your child may or may not be able to make decisions regarding each one of these areas. If you are given the authority to make these decisions for your child, let's say in number 1, the power of residence, that right is then taken away from your child. So your child no longer has the legal right to decide where they're going to live. So let's go through these 7 powers. Let me go back. The power to fix residence, so to decide where you're going to live. This may be a group home, maybe supported living services, maybe remaining home with mom and dad. Number 2, the power to give medical consent, and this includes medications as well. Number 3, to write access confidential records and papers. As you know, with HIPAA regulations, it's very, very difficult to obtain confidential records from doctors, from the regional center, from the school. And while your child is still a minor, you don't really think about that because you have that authority. But when your child turns 18, your child is the one who will have to give consent for you to obtain those records. So if you are going through the limited conservatorship process, this is a really important right that you would want to have. This is also one that we sometimes recommend that you share with your child. So if your child has some abilities and may be interested in their own records, then you may want to share that right so that both you and your child can access their records. Number 4 is the right to contract. Many people don't think this is very important, but especially if you have neurotypical children, you'll know that at the age of 18, they start getting things in the mail that they don't ask for. So credit card applications, cell phone applications, and all they have to do is sign it and throw it back in the mail, and suddenly they have debt. Excuse me. So that really is one that may be more important than you would think. Number 5 is the right to make educational decisions. If your child is still in school, this would allow you to continue to participate in the IEP process and to sign the IEP. After they get out of school, it's also helpful for working with the regional center in determining day program and pre-vocational type activities. 6 and 7 are a little more dicey. Number 6 is the right to consent to marriage. Number 7 is the right to make decisions regarding their social and sexual relationships and contacts. So who are they going to date? Who are they going to marry? Now, these are very, very intimate rights, obviously, and they're rights that we don't like to take away from people lightly. As a parent, I know from talking to a lot of parents, these are really the areas that you're really afraid of and you really want that power. But fortunately, other people are looking at it and deciding and helping you to decide whether or not these rights should be taken away from your child. So if you have the right to consent to marriage, your child can get married. If it's something you didn't know about and suddenly they come home for the weekend and they're married, you would have the right to void that marriage. Excuse me. And if it's something they've worked with you and you've agreed to, then it's fine and it's a legal marriage. The last one is to make decisions regarding their social and sexual relationships. So who do they date? Who are their friends? This is really hard to enforce. You may have that right, but how are you going to enforce it? Okay, let's move on. So the process for petitioning for limited conservatorship, again, is in the probate court. You can either do this by yourself, which is called being in pro per, and there are several pro bono agencies that can help you with the paperwork. The largest one in Los Angeles is called the Beth Clinic. They'll help you with all the paperwork and for serving all the notices, but they will not represent you in court. You'll have to go by yourself. And then you can always hire a lawyer that can help you. LA Court offers a video that I really urge everyone to see. It is a really good representation, an explanation of what your duties are of a conservator. So if you click on to www.lacourt.org, click on divisions, go to probate, and then it'll say non-professional conservator online training. And click on that and watch it. And I really urge you, because it's a great explanation of what your duties will be if you're appointed as conservator. So what the law says is that your duties as a limited conservator are to make sure that your child or the conservatee is receiving all the services and supports necessary to make sure that they are living as independently as possible. So what the probate code section is here on the slide, that you shall secure for the limited conservator all treatment, training, education, services, and supports as appropriate that will assist the limited conservatee in the development of maximum self-reliance and independence. So this is really, really important because this is your job as a conservator. This is your duty. This is not, you don't get to choose whether you do this or not. This is your job as the conservator. And a lot of times you just want to protect your child, and maybe you feel that you just want to keep your child at home for the rest of their lives. But this is your job, is to make sure that they're living as independently as possible. So here's the process. It's very extensive. There's a lot to do. And let me go through this with you. There is a petition and other necessary paperwork that has to be filed. Several documents have to be filed just to initiate the case with the court. You can find these through the LA Court website that we just talked about, and there'll be an area there where we'll talk about forms, and there should be an entire package, so it'll give you all the forms that you need. You may have to go to the court to purchase those forms, but at least the website will tell you which ones you need. You'll fill all of those out. You'll file the petition with the court. You will pay the filing fee, which is right now $465 to file. Or you can apply for a fee waiver. So if your child is receiving SSI, or if anyone in the household is receiving SSI, then you would be eligible for a fee waiver. Depending on your income, you may be eligible anyway. So I always urge everyone to fill out the fee waiver. You then have to give notice. Something called a notice of hearing, which states the date and the time and the department where the hearing will be held. That notice with a copy of the petition has to be sent to relatives, grandparents, parents, and your child's siblings. So your child's grandparents, your child's parents, you, and the child's siblings, with a copy of the petition. The regional center is required to receive notice at least 30 days before the hearing. And the reason for that is the regional center is required by law to file a report to the court on their recommendations. So you will meet with with Lanterman anyway. Lanterman does want to meet with you to discuss what the discuss what the conservatorship is, and to go over the powers with you, and then they will write their recommendation for the court. Also, the court will appoint what they call court-appointed counsel for your child. Your child will have their own lawyer. This is paid for by the court, by the county. You don't have to do that. But that person will represent your child. And if your child is objecting to the conservatorship, then that's what that person will tell the court. Lastly, there is a probate investigator, and this is someone who is the eyes and ears of the court. And the probate investigator will come out and meet with you, meet with your child. They may even talk to the regional center or your child's teachers at school. They will do a background check on you to make sure that you'll be a suitable conservator. And then they will write a report to the court as well. You'll get a hearing. You know, I used to say within 60 days, not 60 days, but 70 days in LA. But now, who knows? We're getting hearing dates 6 months out. So you'll look at the petition when you get it back from the court, and it will tell you what your hearing date is. But you go back on the website for the court, and there is something called probate notes. And the probate notes will tell you if you have any problems with your petition, and that you can fix those problems before you go to court. On the day of the hearing, you and your child must appear in court. If everything goes well and you're appointed as conservator, then there's still more paperwork that you have to file. And there is something called Notice of Client's Rights. And that is a document that says what all the rights are of the conservatee. And that gets served with an order of the conservatorship to all the relatives, the same relatives who received the petition. And then finally, after all of that is done, you will get what's called letters of conservatorship. And it's these letters of conservatorship that act as your proof of being conservator. And you'll give these letters, you'll give a copy of these letters to the school, the regional center, and to all the doctors that your child deals with. You will meet with the probate investigator in 1 year. That person will come back out, meet with you, meet with your child. We'll call the regional center and just make sure everything's still going well. After that, they'll come out every 2 years. And again, they write a report with the court, just letting the court know that everything's going well. So that's a lot to do. There's a lot of work. You can do it by yourself, but there is a lot of work involved in doing the conservatorship. And as you're filing, you'll notice that there's 2 different types of conservatorship, even with the limited. There's of the person and of the estate. And we talked about that a little earlier. Of the person in a limited conservatorship, this means that you have the care, custody, control, and education of the person. So all of those 7 powers that we talked about go under conservatorship of the person. And the second one that you actually have to affirmatively pray for or check the box that says you want to be a conservator of the estate. And that means that you would be managing your child's finances and legal affairs. So it's very, very rare that we ask for estate powers with regional center clients. And the reason for that is our clients receive SSI and Medi-Cal. And so if their only source of income is SSI, you as their parent can become their representative payee. And you can handle their SSI, you can manage their SSI finances as their representative payee. So then you don't have to become the conservator of the estate. If your child has money on their own, maybe they received money through a medical malpractice suit or a personal injury suit, something like that, then you may need estate powers. And if you do have those powers, then you have to file accountings with the court. So it gets pretty involved. So we try not to do that when possible. We just talked about that. So that's it about conservatorships. It's a long, involved process. It's doable. There's lots of help around if you need it. But the important thing is you want to be as informed as possible about what a limited conservatorship is and what your role is in relationship to your child once you become the conservator. So I wish you all the very best of luck. And if you have any questions, feel free to call the KYRC or give my firm a call as well. Thank you so much. Best of luck to you all.